Hi everyone. Again, this is Judge Anarica Castillo Reyes. We will proceed with Chapter 2 of or property in relation to the person to whom it belongs. Article 419 speaks of two kinds of properties depending on the ownership of the said property. It can either be a property of public dominion or a property of private ownership. Previously, in Chapter 1, we discussed property according to its nature, whether it is a movable or an immovable, whether it is fungible or not fungible. Now, this chapter deals with property depending on the person who has appropriated it. In other words, depending on the owner of the property. There are three kinds of owners of property. The primary owner of property, pursuant to the Regalian doctrine, is the state, which is either the national government or its political subdivisions or the local government is. Also, private individuals or private juridical persons may also own property. So there are two kinds of property classified according to ownership. The first kind of property is state-owned property. State-owned property, on the other hand, are of two kinds. There are two kinds of state-owned property. Properties of public dominion and patrimonial properties, both of which are owned by the state. On the other hand, privately owned properties, or those which are owned by private individuals or private juridical persons, have only one classification, and they are properties of private ownership. Now, there is a presumption, always a presumption of state ownership, especially with respect to lands. Okay, because there is no such thing as a land without an owner. Okay, if the land is not registered, it doesn't mean that it is a res nullius or a property without an owner. All lands not appearing to be of private ownership are presumed to be owned by the state. That is the Regalian doctrine, and the burden of proof rests on the person asserting that the land is of private ownership. That is pursuant to Section 2, Article 12 of the 1987 Constitution. Again, there is no such thing as a land without an owner. All lands which do not appear to be of private ownership is presumed to be owned by the state. And it is the burden of the person claiming that he is the owner of the land to prove that he is the owner thereof and not the state. Article 420 speaks of properties of public dominion. When we speak of properties of public dominion, it is only the state which is the owner of properties of public dominion. Okay? Article 420 enumerates those properties of the state which are of public dominion. First is those which are intended for public use. These are properties for the common use or common benefit of the general public. Okay? The most common example would be roads, rivers, river banks, shores, and others of similar character. The pedestrians that you use when you cross the street, those which are intended for public use. And another classification of a property of public dominion are those which are intended for public service. Okay, as long as it performs its function to provide service to the general public, that is a property of public dominion. Example would be government offices, When you go to the DFA to apply for a passport, that is a property. The offices that provide you with that service, that is a property intended for public service or for the development of national wealth. Properties which are intended for the development of national wealth, such as forest lands, timberlands, mineral lands, they are considered as properties of public dominion. Patrimonial property, on the other hand, as we will discuss later, are properties owned by the state in its private capacity. Okay? They are considered as private properties of the state. Okay? They are not intended for public use, public service, or for the development of national wealth. Okay? And therefore, they as properties of the state in its private capacity, it can be the subject of contract and commerce. Okay, now, how about with respect to public dominion properties? Okay, what are the characteristics of these public dominion properties? The first and foremost characteristic of public dominion properties is that they are outside the commerce of men, and thus they cannot be the subject of contracts. Why? Because these properties are intended for the common benefit of everyone. So therefore, no person can appropriate it exclusively for himself. Okay, this is one which is, again, I repeat, this one is uh, for the common benefit of the general public. So anyone has the right to use the said property. It is intended for public use, public service, and for the development of the national wealth. So they cannot be the subject of contract, and no one can appropriate these properties exclusively to themselves. Second, since they cannot be the subject of contract, they cannot be acquired by prescription. Because what will happen if it can be acquired by prescription? Again, okay, the one who has in his favor the prescription will be the owner of that property to the detriment of the general public who has the right to use the same. Okay? Third, they cannot be encumbered, attached, or sold at public auction. Why? Because they cannot be the subject of commerce. So attachment, encumbrance, and sale at public auction are therefore not applicable to these kinds of properties. They cannot be burdened by any voluntary easement because any voluntary easement on a property of public dominion would detriment the public use, public service, and development of national wealth to which they are designed and to which for which their purpose is to provide the said kind of use or service. Okay, and another, the last one, they cannot be registered under the land registration law. Okay, in favor of a private individual or a private corporation. By jurisprudence, the following have been held to be properties of public dominion, meaning that they are intended to provide public use, public service, or they are there to develop the national wealth. Okay, roads, canals, rivers, torrents, ports, bridges, and roadsteads, submerged or foreshore lands, river banks and riverbeds, fishing ports, territorial sea, beach navigable waters and marshy land, unclassified public lands, dried up creeks and riverbeds, building housing embassies of the Philippines in other countries. Okay, Article 421 speaks of patrimonial properties of the state. So all the other properties of the state which is not in the character as Article 420, like it is not intended for public use, public service, or for the development of the national wealth is considered as a patrimonial property. Okay? What if they are no longer intended to be for public use, public service, or for the development of the national wealth? They will also form part of the patrimonial property of the state. However, non-use does not necessarily connote that it is already converted into a patrimonial property, as we will see later in the cases that will follow. Patrimonial property, by definition, are those owned by the state in its private capacity. It exists for the state to sustain its existence and to finance the activities of the government. So all properties that are not devoted to public use, public service, or for the development of the national wealth are patrimonial properties of the state. Property which is officially declared by the President or the Congress, as the case may be, as no longer intended for public use, public service, or for the development of the national wealth are considered as patrimonial properties of the state. Again, patrimonial properties are those which are owned by the state in its private capacity. And therefore, what are the characteristics of patrimonial properties? First, it can be the subject of commerce. So unlike public dominion properties, patrimonial properties can be the subject of commerce. The state may sell it may lease it, encumber it, or assign it to private persons. It is exempt from real property taxes because it is still part of state-owned property unless the beneficial use belongs to a private person. Okay? It can be the subject of eminent domain proceedings. Why? Because it necessarily follows. It can be the subject of commerce, therefore, it can also be the subject of expropriation. What are the examples of patrimonial properties? Properties acquired by the government in execution or tax sales. So mangrove lands and mangrove swamps. Public agricultural lands that are made alienable and disposable by the state. And waterworks. The waterworks in local governments. Okay. We have the case of Chavez versus PLA. Peya, Chavez versus Peya. Okay, Chavez versus Peya tells us that submerged lands, like the waters of the sea or the bay above them, are part of the state's inalienable natural resources. This case involves a government contract that conveyed reclaimed public lands along Rojas Boulevard. The issue in this case is whether Amari, which is a private corporation, can acquire and own a reclaimed foreshore and submerged areas in the Manila Bay. So the Supreme Court said that submerged lands like the waters, sea, or bay above them are part of the state's inalienable natural resources. They are properties of public dominion, absolutely inalienable and outside the commerce of man. This is also true with respect to foreshore lands. Any sale of submerged or foreshore lands is void. Why? Because submerged and foreshore lands are part of public dominion properties. And public dominion properties are properties for the common benefit of everyone. And therefore, you cannot sell the same. It cannot be the subject matter of commerce. Foreshore lands became inalienable as natural resources unless reclaimed by the government and classified as agricultural lands of the public domain. Submerged areas are those permanently underwater regardless of the ebb and flow of the tide. Foreshore and submerged areas are of the public domain and are inalienable unless reclaimed. In order for PEA to sell its reclaimed foreshore and submerged alienable lands of the public domain, there must be legislative authority empowering PEA to sell these lands. So the foreshore and submerged areas are part of the lands of the public domain and other natural resources and consequently owned by the state. The mere reclamation of these areas does not convert these inalienable natural resources into alienable or disposable lands of the public domain. There must be a law or a presidential proclamation officially classifying these reclaimed lands as alienable or disposable and open to disposition or concession. Okay, so what is important in Chavez versus Peya is that submerged and foreshore lands are classified as public dominion properties and therefore it cannot be the subject of commerce. So the mere physical act of reclamation does not make the reclaimed lands alienable or disposable, much less patrimonial properties. So there must be a classification that these lands are alienable or disposable and open to disposition, and a declaration that these lands are not needed for public service. Lands reclaimed by PEA remain inalienable lands of the public domain. It is not for the president to convey real property of the government on his sole will. Any such conveyance must be authorized and approved by law enacted by Congress. So it requires executive and legislative concurrence. So for you to convert these submerged foreshore lands from properties of public dominion to patrimonial properties of the state, there must be executive and legislative concurrence. First, there must be a classification given by the president that these lands are alienable and disposable, and there must be a law stating that these lands are not for public use, public service, or the development of the national wealth. Absent these two requirements, these submerged and foreshore lands cannot be sold, nor can they be the subject of commerce. Okay, we now go to another property which was classified by the High Court as one which is a public dominion property. Okay, this case is Laurel versus Garcia. This case involves the Ropongi property, which is a part of the reparations agreement awarded to the Philippines by the Japanese government as part of the indemnification of for the World War II sufferings. Okay, so the question here is, can the Ropongi property and others of its kind be alienated by the Philippine government? The Ropongi property was previously the site of Chancery diplomatic and consular quarters. However, it was abandoned. So it has not been used for over 13 years. So considering that Article 422 states that those properties which are no longer intended for public use, public service, or for the development of the national wealth, okay, may be declared or are patrimonial properties of the state. So in this case, considering that the Ropongi properties have not been used for more than 13 years, can they now be considered as converted through non-use to patrimonial properties? Remember before, it was a property for public service because it was the previous office of the Embassy of the Philippines in Japan. However, it has been abandoned for 13 years. Okay, the Supreme Court said that as property of public dominion, the Ropongi lot is outside the commerce of men and it cannot be alienated. Its ownership is a special collective ownership of general use and enjoyment, an application to the satisfaction of collective needs and resides in the social group. The purpose is not to serve the state as a juridical person, but the citizens. It is intended for the common and public welfare and cannot be the object of appropriation. How about the non-use for more than 13 years? The Supreme Court said the fact that the Ropongi site has not been used for a long time for actual embassy service does not automatically convert it to patrimonial property. Any such conversion happens only if the property is withdrawn from public use. A property continues to be part of the public domain, not available for private appropriation until there is a formal declaration on the part of the government to withdraw it from being such. Abandonment cannot be inferred from the non-use, especially if it was attributable not to the government's own deliberate and indubitable, but due to a lack of financial support to repair and improve the property. Again, consistent with the previous case, it is not for the president to convey valuable real property of the government on his or her own sole will. Any such conveyance must be authorized and approved by a law enacted by Congress. It requires executive and legislative concurrence. So consistent with the Chavez versus Peya case, this case, Laurel versus Garcia, also required executive and legislative concurrence before a property which is devoted for public service is converted into a patrimonial property. So, being a property of public service, the Ropongi property cannot be sold to a private person. It remained to be a property devoted to public service unless the executive and legislative concurrence required under these cases are met. Okay, we now go to Hilario versus City of Manila. So this case involves riverbanks. Okay, the issue is primarily when a river leaves its old bed, changes its original course, and opens through a private property, would the new riverbanks lining the same would be of public ownership also. So the Supreme Court said that all riverbanks, the river consists of three elements. First is the running waters, the bed, and the banks. All of these constitute a river. And a river, pursuant to Article 420, is considered as property of public dominion. All riverbanks are public ownership, including those formed when a river leaves its old bed and opens a new course through a private estate. Okay, the riverbank is part of the riverbed. So when we speak of rivers, it does not only speak of the waters running in the river as well as its bed, but it also includes the bank. All of those consist of the river and they are considered as properties of public dominion. Okay, we now go to PFTA versus Court of Appeals. The property which is the subject of this case is a port. And pursuant to Article 420, you know that a port is a property of public dominion. Okay, it is one which is of public use. So in this case, real property owned by the Republic or any of its political subdivisions is exempted from the payment of real property tax. This is true whether the property is of public dominion or patrimonial property. However, if the beneficial use of the property has been granted to a taxable person, then that property becomes subject to real property tax. Petitioner PFDA, being an instrumentality of the national government, PFDA is Philippine Fisheries Development Authority. It is exempt from real property tax, but the exemption does not extend to portions that were leased to taxable or private persons. So in this case, the port, which was constructed for public use, being a property of public dominion, the same cannot be subject to execution or forced sale. So, ports, the essential thing in this case, in PFDA versus Court of Appeals, is the fact that ports are classified as properties or for public use. Under Article 420, affirmed also in this case of PFDA, ports are considered as properties of public dominion, and therefore, unless its use is given, its beneficial use is given to a taxable person, the same are considered as exempt from real property taxation, and it also cannot be the subject of execution or forced sales. Okay, we have City of Pasig versus Republic. So this case involves several parcels of land which were surrendered to Mid-Pasig Land by Mid-Pasig Land Development Corporation to the City of Pasig. Okay, now certain portions of these properties were being assessed of real property taxes. Okay, according to the Republic of the Philippines, okay, the properties are exempt from real property taxation because they are properties of the state. Okay, so the portions of the properties not leased to taxable entities are exempt from real estate tax, while the portions of the properties leased to taxable entities are subject to real estate tax. So in this case, the parcels of land are not properties of public dominion because they are not intended for public use. Okay? Neither are they intended for some public service or for the development of national wealth. MPLDC leases portions of the properties to different business establishments. Thus, the portions of the properties leased to taxable entities are not only subject to real estate tax, they can also be sold at public auction to satisfy the tax delinquency. Okay, so remember, these are part of the properties that were surrendered, voluntarily surrendered by Jose Campos, which is a former crony of the late President Marcos. So he voluntarily surrendered these properties to the government, to the Republic of the Philippines. So the City of Pasig is assessing real property tax on the said properties. So the government is contending, no, it is not subject to real property tax because these are public dominion properties. But the Supreme Court held that these are not properties for public use, public service, or for the development of national wealth. And in fact, several portions of these lots were being leased to private individuals, and therefore, it is subject to real estate taxation. Okay? Another case, FCBPFAI versus Secretary of the DENR. So this case involves farmland which are occupied by members of Sambico and which were placed under the Comprehensive Agrarian Reform Program. However, the implementation of the CARP was suspended because the said lands were classified as forest lands. And if it is classified as forest land, it cannot be the subject of commerce because it is a property of public dominion. Okay, so in this case, the court reiterated the Regalian doctrine. According to this case, all lands not appearing to be under private ownership are presumed to belong to the state. Again, there is no such thing as a land without an owner. If a land is without an owner, the default owner is always the state. And it is incumbent upon the person asserting ownership into him unto himself to prove such ownership. Also, public lands remain part of the inalienable land of the public domain unless the state is shown to have reclassified or alienated them to private persons. So the law does not provide any presumption that a land of public domain is agricultural. Notably, it merely gave the said government the prerogative to classify land. Nothing states that unclassified lands are automatically treated as agricultural land, which are alienable and disposable. So what is involved in this case is unclassified forest land. Okay, so remember in land registration cases, only agricultural lands can be classified as alienable and disposable. With respect to forest lands, the government is without any power to reclassify the same as alienable and disposable lands. When a land of the public domain is unclassified, it cannot be released and rendered open for private disposition pursuant to the Regalian doctrine, and that the private applicant in a land registration case has the burden of proof to overcome state ownership. So again, absent any positive act of the government to classify a land of public domain into alienable or disposable land for agricultural or other purposes, it remains with the state. So an unclassified forest land is a property of public dominion. Unless the state reclassifies the said land as alienable and disposable agricultural land, it remains to be property of public dominion and therefore cannot be the subject matter of commerce. A forested area classified as forest land does not, by mere classification simply because loggers may have stripped it of its cover. Parcels of land classified as forest land may actually be covered or planted to crops by kaingin cultivators. Forest lands may be on mountains or in out-of-the-way places. Swampy areas covered by trees, nipa palms, and other trees growing in brackish or seawater may also be classified as forest land. So unless and until the land classified as a forest is released in an official proclamation to that effect so that it may form part of the disposable agricultural lands, the rules of confirmation of imperfect title do not apply. Unclassified land should be presumed as disposable land and not a forest land, would run afoul to the Regalian doctrine. Any person could simply declare that a parcel of land of public domain is alienable and disposable by the mere fact that it is not covered by trees. So the traditional connotation of a forest land that it is covered by trees is not always true. There can be forests, the mangroves are considered as forest lands even if it is in swampy areas. So only when the lands of the public domain are classified as alienable or disposable may petitioners assert their property rights over the subject lands. Okay, we now have the case of Villarico versus Sarmiento. So in this case, petitioner's lot is separated from the Ninoy Aquino Highway by a strip of land which is owned by the government. So as this highway was elevated by 4 meters, the DPWH constructed stairways at several portions of this strip of public land. Now, this blocked the petitioner's lot access to the highway. So, he filed a case for publiciana, action publiciana, and alleged that respondent structures close this right-of-way to the highway and encroach on a portion of his land. Okay. So in Villarico versus Sarmiento, the court found the occasion to reiterate the characteristics of a property of public dominion. A property of public dominion is outside the commerce of man, and it cannot be alienated or leased or otherwise be the subject matter of contracts. It cannot be acquired by prescription against the state. It is not subject to attachment and execution, and it cannot be burdened by any voluntary easement. So considering that the lot on which the stairways were constructed is a property of public dominion, it cannot be burdened by voluntary easement of right-of-way in favor of the petitioner because he wanted to have a right-of-way on a portion of the lot which belonged to the state. Okay, considering that that lot was classified as a property of public dominion, it cannot be subjected to any easement. Okay, because it would cause an encumbrance on the property which is being used by the public. Petitioner cannot appropriate it for himself. He cannot claim any right of possession over it. Okay, so another case is Celestial versus Cachopero. Okay, in this case, the court declared that a dried up creek is considered, or a riverbed is considered as property of public domain. It is only after the government has declared to be the land to be alienable and disposable that the year of entry, cultivation, and exclusive possession can be counted for the purpose of an imperfect title. So in this case, what was involved is the Salunayan Creek. The Salunayan Creek is including its bed, is a property of the public domain, which is not susceptible to appropriation and acquisitive prescription. Absent any declaration by the government that a portion of the creek has dried up, does not by itself alter its inalienable character. So the Salunayan Creek, a portion of which became dry because there was an irrigation canal that was constructed. So the dried up portion was actually caused by the active intervention of man. It follows that Article 370 does not apply, and hence the petitioners cannot be entitled thereto supposedly as riparian owners. So these riparian owners are claiming ownership of the portion of the creek that has dried up. Okay, however, the Supreme Court said that does not mean that if the river dries up, it does not mean that the dried up portion of the river becomes the property of the riparian owners. Okay? Especially if the reason why the river has dried up is because of man-made intervention. Okay? In the instant case, it is not even alleged that the Salunayan Creek changed its course. Because if the river changed its course, okay, the property which was occupied by the new bed, the owner of which will compensate himself by becoming the owner of the portion of the river, the former bed of the river becomes his property. Okay, in this case, the river did not change its course. The river dried up because of man-made intervention, which is due to the construction of the irrigation canal. So therefore, the dried up riverbed still retained its character as property of public domain. Cebu Oxygen versus Versailles. So in this case, what is important is Article 422 states that if property is no longer needed for public service, public use, or for the development of the national wealth, does it automatically convert itself to patrimonial property? Cebu Oxygen versus Versailles tells us that in this case, does the declaration of the road as abandoned make it patrimonial? Because there is a city road which is no longer being used. So what the city of Cebu did was to enact an ordinance declaring that the portion of that city street is considered as closed. So the Supreme Court said these are acts which are well within the ambit of the power to close a city street. The city council has the authority to determine whether or not a certain property is still necessary for public use. Since that portion of the city street was withdrawn from public use, it follows that such withdrawn portion becomes patrimonial property, which can be the object of an ordinary contract. So Article 422 of the Civil Code provides that property of public dominion when no longer intended for public use or service shall form part of the patrimonial property of the state. Okay, so it is not self-executory just because a road, for example, is no longer being used. That doesn't mean that the same automatically becomes patrimonial property. Cebu Oxygen versus Versailles tells us that the closure of the road by the city council is needed in order to make that property as patrimonial property. So the act of the city council in declaring the road as closed and therefore is no longer intended for public use. It is needed in order to convert that portion of the road into a patrimonial property, and therefore, being a patrimonial property, it can now be the subject of commerce. So let us go to PNOC versus Philippine National Oil Company versus National Grid Corporation of the Philippines. So what was involved in this case is the lot, okay, of PNOC, which is being used as petrochemical industrial park. Okay, certain portions of the petrochemical industrial park is being leased by PNOC to private locators inside the park. Now, NGCP wants to construct transmission lines for the Maribeles Limay 230 kV transmission towers. So the question in this case is, are the properties inside the petrochemical industrial park considered as public domain properties, and therefore they're already being they're already for public use and therefore cannot be the subject of expropriation. Okay, there are three kinds of properties of public dominion: those for public use, public service, and for the development of national wealth. Inalienability is an inherent characteristic of a property of public dominion. This characteristic necessarily crashes with an express declaration of alienability and disposability, in that when public land is declared by the state to be subject to disposition, it ceases to be land of public dominion. So properties owned by the state which do not have these characteristics are patrimonial properties, meaning that they are owned by the state in its private capacity. The state has the same rights and the same power of disposition as private individuals with respect to patrimonial properties. The purpose of patrimonial properties is in order for the state to attain its economic ends or objectives, to serve as means for its subsistence and preservation, and to better fulfill its primary mission. Okay, in PNOC, the court found the occasion to declare the patrimonial properties of the state, such as those which are acquired by the state in execution or tax sales, mangrove lands and swamps, uh, were also considered as patrimonial property, as well as waterworks. So, patrimonial properties are either by nature or use, and by conversion, or those covered by Article 422. Upon the declaration of alienability and disposability, the land ceases to possess the characteristics or properties of public domain. Once a property of public dominion is declared as alienable, it becomes the subject of private rights. So in this case, with the subject property expressly declared by law, which is PD 949, to be an industrial and commercial estate that may be transferred or conveyed to private persons so that business activities may be conducted therein, there is no doubt that the subject property is patrimonial property. In other words, respondent NGCP has the authority to expropriate the subject property. Why? Because aside from the law, which is PD 949, these properties are being leased to locators, which are private corporations, and they may even be sold. Okay, so they can be the proper subject of commerce. If it is a property of public dominion, it cannot be the subject of commerce. Since these are patrimonial properties of the state, it can be subjected to expropriation. Okay. Now we go to Articles 423 to 425. Okay, these are the properties of political subdivision as well as privately owned properties. So unlike properties of the state, meaning the national government, which are of three kinds: property of public use, public service, or those for the development of national wealth, properties of political divisions are only of two kinds: those which are for public use and those which are patrimonial. Okay, properties for public use of local government are the following: provincial roads, city streets, municipal streets, squares, fountains, public waters, promenades, public works for public service. All other properties are considered as patrimonial. Okay, the rest of the properties with respect to how about properties of private individuals? There is only one kind of property with respect to private individuals or corporations, and these are private properties. Okay, properties of local government units in their private capacities are patrimonial properties. Okay. With respect to properties of private ownership, they consist of all the properties belonging to private persons, either individually or collectively. When we say collective ownership, okay, it includes co-ownership and ownership by juridical persons. Now we go to the topic of conversion. Can a property, which is of public dominion, be converted to patrimonial property? Okay, the answer is yes. This is a topic under land registration laws. Section 14-1 of PD 1529 in relation to Section 48B of Commonwealth Act number 141 states that PD 1529 is the property registration decree. Okay? Land registration. On the other hand, Commonwealth Act number 141 is the Public Land Act. Okay. Section 14-1 of PD number 1529 states that if the applicant or his predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of the land sought to be registered under a bona fide claim of ownership since June 12, 1945 or earlier, he may file an application for land registration. Okay, remember the Regalian doctrine? Okay, the presumption is that all lands are presumed to belong to the state. Okay, now whoever alleges that that land is of private ownership must prove the same. So, Section 14.1 of PD number 1529 and Section 14.2 of PD number 1529 speaks of the requirements, okay, for a person asserting his ownership of a land, which is presumably owned by the state. Okay, so if you, for example, okay, is asserting that a certain land is yours or belongs to you in ownership, then you have to file an application for registration of the said land, either judicially or administratively. Now, what would be your basis for claiming ownership? Your basis for claiming ownership would be either of these two sections of PD number 1529 in relation to section 48 of CA number 141. Okay, you can assert under section 14.1 a confirmation of your imperfect title, provided that you can prove that you have been in open, continuous, exclusive, and notorious possession of the land since June 12, 1945 or earlier, and that the land has been classified by the Executive Department as alienable and disposable land of the public domain at any time before the filing of the application. Because remember, only alienable and disposable lands may be the subject of confirmation of an imperfect title. Okay? To prove this, to prove that the land, the classification of the land, you have to submit the following documents. First, a copy of the original classification of the land approved by the DNR Secretary. Okay? Second, a certificate of land classification status issued by the CENRO or the PENRO based on the land classification approved by the DNR. So two certifications of land classification, one coming from the Secretary of the DNR and another one coming from the CENRO or the PENRO. Okay? Another basis by which you can claim that the land is owned by the applicant is section 14.2 of PD 1529. So, in this case, you are claiming ownership by reason of acquisitive prescription under the Civil Code. In this case, it is not only required that the land is alienable and disposable, but it is required that the property has been considered and declared as patrimonial property of the state. Okay? If the occupation and possession of the land commence at any time after June 12, 1945, the applicant may still register the land if he or his predecessors in interest have complied with the requirements of acquisitive prescription under the Civil Code after the land has been expressly declared as patrimonial property or no longer needed for public use, public service, or the development of the national wealth. Prescription begins to run from the date of the official declaration that the property has been withdrawn from public use. So how is Section 14-2 different from Section 14-1? Remember that in 14-1, your possession of the land must begin from June 12, 1945 or earlier. And the land subject of the application under Section 14-1 is unalienable and disposable land declared by the executive department. On the other hand, Section 14-2 of PD 1529 states that if your possession has commenced later than June 12, 1945, okay, and you're claiming acquisitive prescription, whether ordinary or extraordinary, the land must not only be alienable and disposable, it must be expressly declared as patrimonial property of the state. Okay? There are several landmark decisions that will further explain to us the manner of acquisition of land ownership. Tan versus Republic. Okay, petitioners filed an application for land registration covering a parcel of land pursuant to a deed of absolute sale. And they allege that they have been in open, continuous, exclusive possession of the property for more than 30 years. So they are claiming under PD 1529, Section 14-1. Section 14-1 covers alienable and disposable lands, while Section 14-2 covers private property. Remember the distinction, ha? The private property contemplated in 14-2 is patrimonial property. Possession and occupation of unalienable and disposable public land for the periods provided under the Civil Code will not convert it to patrimonial property. There must be an express declaration that the property is no longer intended for public service or the development of national wealth. In other words, for one to invoke the provisions of Section 14-2 and set up acquisitive prescription against the state, it is primordial that the status of the property as patrimonial be first established. So, if you are claiming acquisitive prescription under Section 14-2, first, you must prove that the property you are claiming has been expressly declared as patrimonial property of the government, and you have to prove your possession of the property for either 10 or 30 years, depending on the good faith or bad faith. So how do you prove possession? You prove possession through tax declarations. So in this case, the taxes were paid only on 11 occasions within the 40-year period. So petitioner's application was filed after only 1 year from the time that the subject property was considered as patrimonial. So if you are claiming under Section 14-2, the 10 or 30-year period of prescription must be counted not from the time that you occupied the property, but from the time that the property has been declared as patrimonial. Republic versus Cortes. In this case, Cortes filed an application for judicial confirmation of title. Okay, in support of his application, Cortes filed a survey plan with annotation that the property is already classified as alienable and disposable. So under Section 14-1 of PD 1529. Applicants for registration must sufficiently establish, first, that the subject land forms part of the disposable and alienable lands. Second, that the applicant have been in open, continuous, exclusive possession of the property, and the same is under bona fide claim of ownership since June 12, 1945 or earlier. So Cortes' reliance on the annotation in the survey plan is amiss. It does not constitute incontrovertible evidence to overcome the presumption of state ownership. Okay, the applicant must at the very least submit a certification from the proper government agency stating that the parcel of land is indeed alienable and disposable. So to prove that the land subject of an application for registration is alienable, an applicant must establish the existence of a positive act of the government, such as a presidential proclamation or an executive order or an administrative action, investigation reports of the Bureau of Land Investigators, and a legislative act or statute. So in this connection, the court has held that he must present a certificate of land classification status issued by the Senro or the Penro. He must also prove that the DNR secretary has approved the land classification. So there are two certifications needed to prove that the land is indeed alienable and disposable, issued by the DNR secretary as well as the Senro and Pen. So the annotation in the survey plan is not the kind required by law as proof that the subject property is indeed alienable. Having failed to present any incontrovertible evidence, Cortes claimed that the subject property forms part of the alienable and disposable land must fail. Okay? So also the court emphasized that there must be an official declaration by the state that the public dominion property is no longer intended for public use, public service, or the development of national wealth. A mere declaration by government officials that a land of the public domain is already alienable and disposable would not suffice. Accordingly, there must be an express declaration by the state that the public dominion property is no longer intended for public service. That is with respect to Section 14-2 or prescription. Such declaration shall be in the form of a law duly enacted by Congress. Okay? Before acquisitive prescription could commence, the property sought to be registered must not only be classified as alienable and disposable, but it must also be declared by the state that it is no longer intended for public use, service, or the development of the national wealth. Absent an express declaration, the land remains to be property of public domain. The court finds no evidence of any official declaration from the state attesting to the patrimonial character of the property. The indispensability of an official declaration that the property is now held by the state in its private capacity or placed within the commerce of man for prescription to have any effect against the state cannot be overemphasized. So remember that if you are claiming under Section 14, paragraph 2 of PD 1529, okay, it is not only sufficient that the land be declared as alienable and disposable, there must be also a positive act coming from Congress in the form of a law that the property has been withdrawn from public use, public service, or the development of national wealth. It is only at this time when the government has expressly declared the property to be patrimonial that the acquisitive prescription will run. It is not from the time of your possession, of the applicant's possession of the said property, but it is from the time that the property has been declared to be patrimonial. Okay? We now go to the landmark case of Dumo versus Republic. So, In an application for land registration, it is elementary that the applicant has the burden of proving by clear, convincing evidence that her possession and occupation were of the nature and of the duration required by law. So the Supreme Court, through Justice Carpio, in the case of Dumo, has enumerated the requirements for the applicant for land registration. Uh, to prove, the applicant has the burden of proving the following requirements. Number one, that the land or property forms part of the alienable and disposable lands of the public domain. Okay, this is for confirmation of imperfect title, ha? Section 14-1 of PD number 1529. So you must prove first that it is an alienable and disposable land of the public domain. Okay, that the applicant have been in open, continuous, exclusive, and notorious possession and occupation of the same, and that it is under a bona fide claim of ownership since June 12, 1945 or earlier. So how do you prove that the land is alienable and disposable land? Okay, the classification of lands of the public domain into agricultural lands, as well as their further classification into alienable and disposable land, is a legislative prerogative which may be exercised only through the enactment of a valid law. This prerogative has long been exercised by the Congress through the enactment of Commonwealth Act number 141. So to be alienable and disposable, it must be expressly declared by the executive or administrative proclamation pursuant to a law or by an act of Congress. So Congress has delegated to the President the power to classify lands. Okay, this power is delegated to the President, who may classify agricultural lands as alienable and disposable. As it is only the President or the DENR Secretary who may classify as alienable and disposable lands of the public domain, an applicant must prove that the land sought to be registered has been declared by the President or the DENR Secretary as alienable and disposable. Okay, so what are the documents that you have to submit? You must present a copy of the original classification approved by the DENR Secretary, and also a certificate of land classification status issued by the CENRO or the PENRO. To repeat, there are two documents which must first be presented: a copy of the original classification approved by the Secretary of the DENR, and a certificate of land classification status issued by the CENRO or the PENRO. So submitting a mere certification by the CENRO or the PENRO is inadequate and has no probative value. Thus, it is clear that if the applicant is applying for registration of land under paragraph 1, the possession and occupation should have commenced from June 12, 1945 or earlier. If, however, the applicant is relying on the second paragraph, then it is true that a different set of requirements applies. So the property sought to be registered must be declared alienable and disposable at the time of the filing of the application for registration. This does not require that the land be declared alienable and disposable from June 12, 1945 or earlier. That applies to Section 1 of PD 1529. If you are applying for confirmation of your imperfect title, it is only needed that the land must have been declared alienable and disposable at the time of the filing of your application. Although your possession and occupation of the property under claim of ownership has started since June 12, 1945 or earlier, the declaration that the property has been alienable or disposable need not be from June 12, 1945 or earlier. It is sufficient that at the time that you filed your application for registration, that land has already been classified as alienable and disposable. So in this case, Dumo also argued that she had the right to register the land because he has acquired it through prescription. So now he is claiming that if I cannot have the land registered under Section 14, Paragraph 1, I can have it registered through prescription under Section 14, Paragraph 2 of PD 1529. Okay. Property of the state, not patrimonial in character, shall not be the object of prescription. Okay. Lands of the public domain is converted into patrimonial property when there is an express declaration by the state that the public dominion property is no longer intended for public service or the development of the national wealth. Without such declaration, acquisitive prescription does not start to run, even if such land is alienable and disposable and the applicant is in possession and occupation thereof. Mere classification of agricultural land as alienable and disposable does not make that land patrimonial. An express declaration by the state that the land is no longer intended for public use, service, or the development of the national wealth is imperative. Okay? Alienable and disposable lands of the public domain are those that are to be disposed of to private individuals because their disposition to private individuals is for the development of the national wealth. Land of the public domain become patrimonial property only when they are no longer intended for public use, service, or the development of the national wealth. Without an express declaration that the land is no longer needed for the said purposes, it should be presumed that the lands, whether alienable and disposable or not, remain belonging to the state under the Regalian doctrine. To repeat, acquisitive prescription only applies to private lands. If you are claiming prescription under Section 15-2, the land must be declared to be private or patrimonial. It is not sufficient that they are declared only by the executive department as alienable and disposable. Unless the alienable and disposable land is expressly converted in patrimonial property, there is no way for acquisitive prescription to set in. Okay, so in other words, Dumo summarize the requirements for land registration as follows. Okay, if the applicant or his predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of the land sought to be registered under a bona fide claim of ownership since June 12, 1945 or earlier, the applicant must prove that the land has been classified by the executive department as alienable and disposable land of the public domain. The applicant must prove that the president or the DANR secretary has classified the land as alienable and disposable land at any time before the application was made. If the occupation and possession of the land commence after June 12, 1945, the applicant may still register the land if he or his predecessors have complied with the requirements of acquisitive prescription under the Civil Code after the land has been expressly declared as patrimonial property or no longer needed for public use, public service, or the development of the national wealth. This is governed by Section 14-2 of PD number 1529. Under the Civil Code, acquisitive prescription, whether ordinary or extraordinary, applies only to private property. Thus, the applicant must prove when the land sought to be registered was expressly declared as patrimonial property, because it is only from this time that the period for acquisitive prescription would start to run. Philippine versus National Housing Authority. So in this case, the petitioners argued that they have been in open, continuous, exclusive, and notorious possession of the illegal property for more than 30 years. So they are claiming under Section 14-2 of PD 1529. So for acquisitive prescription to set in, two requirements must be satisfied. First, the property is established to be private in character, and second, that the applicable prescriptive period has passed. So, contrary to petitioner's theory, for prescription to be viable, the publicly owned land must be patrimonial or private in character at the onset. Possession for 30 years does not convert it into patrimonial property. There must be an express declaration in the form of a law duly enacted by Congress that the public dominion property is no longer intended for public service or for the development of the national wealth. A mere endorsement of the executive secretary is not the law or presidential proclamation required for converting the land into patrimonial property. So the need for the land subject of the claim to have been classified as agricultural is in conformity with the constitutional precept that alienable lands shall not be limited to agricultural lands. So in this case, the illegal property has already been declared to be alienable and disposable land. Second, although the Delphine spouses the evidence that they have presented show that their possession went only as far as 1952. There is evidence consisting of letters to the director of land that the property had already been occupied as early as June 1945. Okay, now we come to the final case for land registration, and that is Republic versus Tan. In this case, Tan applied for the original registration of a lot, okay, which was granted. Okay, the Republic or the state appealed the case, considering that according to the state, the petitioner failed to prove all the requirements for her application. Okay, all lands of the public domain belong to the state. It is the fountain from which springs any asserted right of ownership over the land. This is the Regalian doctrine. Okay, the property registration decree recognizes prescription as a mode of acquiring ownership. Nevertheless, prescription under Section 14-2 must not be confused with judicial confirmation of title under Section 14-1. Judicial confirmation of title requires the following: that the applicant is a Filipino citizen, that the applicant or his predecessors have been in continuous open possession of the property since June 12, 1945, and that the property had been declared alienable and disposable as of the filing of the application. So in this case, Tan's application is not anchored on judicial confirmation because she does not claim to have possessed the property since June 12, 1945. Her application is based on acquisitive prescription. Okay, property of public dominion is alienable and disposable does not ipso facto or automatically convert it into patrimonial property. While a prior declaration that a property has become alienable and disposable is sufficient with respect to Section 14.1, it does not suffice for the purpose of prescription under Section 14.2. Before prescription can even begin to run, the following conditions must be present. Okay, first, the subject lot must be classified as agricultural land. The land must be classified as alienable and disposable. And in addition to that, There must be a declaration from a competent authority that the subject land is no longer intended for public use, thereby converting it into patrimonial property. In this case, the third condition is absent. Even though it has been declared alienable and disposable, the property has not been withdrawn from public use or public service. Without this, prescription cannot begin to run because the property has not yet been converted into patrimonial property of the state. Okay, so that's it for property in relation to the person to whom it belongs. Thank you for listening.